The decision by the court to grant a stay, especially for 45 days, and on the strength of an application, an oral application done by Parliament, that they also intend to have a period within which they can try and validate the regulation to support the housing fund, in our view, is highly irregular and unfortunate, and takes away what the court has just given in terms of making the right finding. As we have always argued, that the law is unconstitutional because it lacks a legislative framework. So what we view this decision is an attempt to give the government an opportunity and enough time to be able to put its house in order, to be able to enact the legislation that then is going to be the foundation for the housing fund, for the affordable housing levy, and also enable the government to collect money that it was collecting without a legal basis, and notwithstanding the fact that the court has found that to be unconstitutional. So not only was that unconstitutional, but the collection of the money by the Kenya Revenue Authority was also found to be contrary to the law. So there are two wrongs that have been given a new lease of life by the decision that the court has given. This is a radical departure from what other courts have done when it comes to assessing and considering the question of whether or not to grant a stay after a decision has been made. It would have been in order that the application is formally filed so that parties have the opportunity to respond, and for the court to appreciate the magnitude of the decision that has been rendered. So for the court to give those kind of orders and to have them stay and be valid for a period up to 10th of January 2024 is to actually render any proceedings that are going to be held in the Court of Appeal as moot and academic, because already the court has granted far-reaching and unusual orders of stay of execution. So in a sense, the court has given with one hand and taken with the other, and it looks like except for the fact that the arguments that had been presented in support of the case were weak, it looks like initially the court was of the mind that it needs to find a way to sustain the housing levy, because you cannot take it that they had any other intention other than to find a way to keep this law, which is clearly unconstitutional and which clearly the entire country is aggrieved against, and conduct themselves in the manner in which they have conducted themselves.
All the same, respondents say they are going to the Court of Appeal. They're going to file immediately. What's your take on this?
They have an undoubted right to approach the Court of Appeal, and the proper thing would have been for the court to allow them to exercise that right, and for the court to give us an opportunity to meet at the Court of Appeal and litigate on the question of whether or not the court should grant them stay. By virtue of the fact that they already have an automatic stay in the High Court, in our view, almost renders the proceedings that are going to be filed in the Court of Appeal as moot, because then the court would be saying, why don't we just sustain this stay as we hear this matter, so that then you either expedite the hearing of the main appeal or something, and buy the government more time to be able to proceed with the ongoing, because there is already a publication of housing, affordable housing proposals that are being considered by Parliament for purposes of enacting a foundational law. And so you see this almost looks like a scheme to ensure that the housing fund, irrespective of whether it complies with the law right now or not, is collected until such time when the government would be able to put its house in order and regularize the illegalities that we have pointed out in this legislation. And that for us is where we lose in this entire scheme, because the effect of the decision should have been felt, and then Parliament and government then has an opportunity to review this. We say this because as a law society we have previously advised that the manner in which the government has approached the question of the housing levy was contrary to the law, and we had advised that if they intend to achieve this objective, that they need to create a law. Now what is happening is that upon realizing the mistake they have done, they have now commenced the process of regularizing, and what the court is doing is to give them that window of opportunity to be able to regularize, and it almost feels as if the court is working in cahoots with the state.